We're going to talk about caring for the victim. As we discussed in the first part of this chapter, the treatment of victims in America has changed greatly over the last 100 years. Helping victims cope with victimization has become and is the responsibility of society. Victim services, they have grown in the country along with an emphasis on the rights of victims, and that sort of began in the 1960s, 1970s. Although a federal victims' rights amendment to the U.S. Constitution has yet to be passed, a number of federal laws do offer protection and rights to victims of crimes. In 1982, Victim and Witness Protection Act was passed, and this basically requires judges to consider victim impact statements at federal sentencing hearings, and it places the responsibility for the creation of these victim impact statements on federal probation officers. We're going to talk about victim impact statements in more detail in a little bit. This is kind of an overview of the laws that have been passed to help victims. In 1984, the Federal Victims of Crime Act was passed, and this act authorized funds to be dispersed to states to help establish victims assistance and victims compensation programs. So those are federal statutes. All of the states now have some sort of victim service programs. Types of victim services, government programs that help crime victims and witnesses. They do that in a number of ways to assist them, including court services or compensation and fees, or even crisis intervention. It's not just victims, even though victims are witnesses in cases. There's other people who are witnesses who weren't really victims, but they still need some sort of assistance or protection, certainly depending on the case and who the offender is and what's involved. There is the victim witness assistance protection programs from dangerous offenders, right? They want to keep the witnesses safe from intimidation or even becoming a victim. I think I've already said that a witness is not necessarily a victim. A witness is somebody who has material relevant information relevant to a crime. That's considered a witness. They have without this witness, the prosecutor wouldn't be able to prove a portion or an element or a part of a criminal case. So it's crucial to keep our witnesses safe. Other types of services, victim compensation. The goal is to reimburse the victim for expenses lost or incurred as a result of a crime. Some examples would be losses of property, medical expenses, economic support, counseling, lost wages, even emergency compensation such as housing. If they're deemed homeless as a result of the crime, or if they need food. If we're dealing with someone who was murdered, the victim's family might be compensated burial or funeral expenses. That's what the victim compensations boards is what they call them, provide. The Federal Victims Crime Act, as I mentioned above, is the one that funds states' compensation boards and helps with the expenses as well. And the money, you might be saying, well, where does this money come from? Taxpayers? Nope. This money comes from fines and penalties that were imposed on federal offenders. So the fines and fees that get imposed as a result of a crime go into the funds for the Federal Victims Crime Act. I'll talk about the states in a little bit, specifically New York. And actually, I'm going to go there right now. The New York State Office of Victim Services exists in New York State. And like I said, every state has one of these. It's a New York State agency that provides information about victim services, resources, and legal rights. These rights are found in our various laws, our New York executive law, our New York penal code law, that's our criminal law. The executive law governs our corrections and our parole and other areas, but for our purposes, that's where we find those laws from the executive law. And under various rules and regulations set forth by the state on how agencies are supposed to run. These rights include victims' rights to compensation or restitution. Restitution is something that the offender pays as a result of their crime. I'll speak a little bit more on restitution in a second. And they also provide information on and notification of court proceedings, the types of judicial proceedings, among other rights that they're allowed to. And there is a actual booklet that they provide, the New York State Office of Victim Services provides to victims, and I actually made a link to it on Moodle, so you can take a look at what New York State's Victims Assistance Program has to offer. In a lot of states, the majority of the states, it's very similar. Now, back to my criminal defendant. As part of a criminal defendant's court case, they could be required or ordered to pay for the expenses that the victim has suffered as a result, and that's called restitution. But also courts are required to impose a crime victims fee, and that's the money that goes to our New York State fund for criminal victims. The federal system has one. That money filters down to the states for assistance for crime victims, as well as New York State to fund their programs has one with state-related cases as well. And the range is anywhere between $25 and $175, depending on the type of case involved. How much money does this federal fund have? The feds provide the fund with a budget of $3.042 billion every year. So it's quite a large fund. New York City has the New York City Human Rights Law that also protects victims of domestic violence, stalking, and sex offenses, as well as discrimination in employment. So there's a lot of compensation going on for victims, various resources available. Victim advocates is something that is found they're found within various programs, but they can be independent advocates as well. But let's talk about them in the form of programs. So there are programs that assign a counselor or other individual to advocate in support of the victim throughout the whole justice process. So they help them understand the process and how to get them through it. They may transport them to and from their court proceedings. They may even explain the various steps involved. It's going to depend on the level of the education of the advocate. There are specific types of advocates for different kinds of cases. Domestic violence advocates. We have one here in Clinton County, Stop Domestic Violence. They're very common to support people and go with the individual victim to appointments at the DA's office or in court proceedings, or help them get some paperwork filed in court that they may need. There are people who have been sexually assaulted that can be assigned an advocate. Some states have an advocate liaison right in the district attorney's office for families of murder victims. They provide the family with immediate assistance and support. Here in Clinton County, we have a child advocacy center, and it's for children who have been abused physically, verbally, or sexually. So there are a number of types of advocates that are available to victims of crimes. want to talk about these victim impact statements. There is a short video on Moodle it's short, it's 2 minutes. And another additional resource of a victim actually giving a statement in court. I think you should view those. These are very impactful. I guess that's why they call them impact statements. And I'll tell you about them first, and I'll tell you about their impact. So these victims' impact statements, these are statements that the victims get to make, or their families get to make in open court to the judge with the defendant present. Every state and federal criminal justice system allows for this. It's in the law. And what it does is provide the victim with the opportunity to speak about his or her experience, describe the whole ordeal, what happened, how it affected them. The rationale behind this is that as a victim of the case, they should be allowed to influence the outcome of the case, that they should have a say and they should be heard because everybody else does. Right? Under the law, the prosecutor, on behalf of the public, gets to state what should be the sentence imposed. The defense attorney gets to stand up and say what the sentence should be imposed, and the defendant, under the law, under the Constitution, has a right and an opportunity to address the court at sentencing. So why not the victim? But there is great debate with regards to it. Research shows that these statements result in higher convictions. It affects the decision over incarcerating defendants versus the defendant getting community supervision. I will tell you, as a former defense attorney, I would cringe when I knew that the victim would be in court to speak, because it gets a lot of weight. The victim gets noticed. It is very impactful, and I have seen judges hand down mandatory prisons, the maximum prison sentences after hearing from a very persuasive victim. Now, I wouldn't say, and I couldn't say that, that was the ultimate decision, but a lot of impact statements come in through the probation department. They reach out to the victims and they send them a packet, questionnaire, and say that this is going to go to the judge. It's the prosecutor who would reach out and say, hey, you have a right to speak in court if you want to come. Most folks that's intimidating and don't particularly want to, but the ones that do certainly are very, very persuasive from what I've seen in person. A nationwide case involving, you may have heard about it, the nationwide case involving the Larry Nassar, the former U.S. gymnastics coach, who over a period of, decades, sexually assaulted hundreds of women. And he was charged with many, many counts of sexual assault. Well, at his sentencing, over 100 victims showed up to make statements. At one point, the defendant asked the judge to make it stop because it was affecting his mental health. She didn't, and because the victims have a right to be there. And he was sentenced to 45 to 175 years in federal prison. So if you want to learn a little bit more about that case, you can Google it or watch the victims' impact statements. But I posted one on Moodle for you guys to see. Public education is something else that's available to victims. These programs, and not just victims, but to the public as well. These programs provide the community education in schools and at other public forums. It provides the information about what their services are in the event that anybody needs them, but it also provides preventive programs, like education and awareness, so no one becomes a victim. So it's kind of a two-sided public education. Crisis intervention. This is different from advocacy, in that these programs provide emergency counseling for crime victims, services that are immediate, crisis intervention. It has to be services that are immediate. They provide shelter, they provide food, medical care, clothing, anything that needs immediate attention. That is what programs, victim services programs involving crisis intervention offer. There are also victim offender reconciliation programs. These programs put the victim and the offender in the same room. Now you might be wondering why would they do that? They do this to to mediate the issues between them. Maybe they do some meditation too, such as restitution. Right? If we're dealing with a property crime or a petty theft, they might be able to work it out, especially if they know each other, because generally the victim and the offender know each other. If there's a possibility of reconciliation between them. Attempted murder. If somebody's charged with attempted, may sound crazy. Somebody's charged with attempted murder, and we're going to put two people in the same room and see if they can work out their issues. But you got to think these people know each other. Maybe it was a domestic violence case that didn't turn out very well, and the DA's office charged with attempted murder. Maybe it was an offense that started with two people who were drinking, and then they got into an argument. Remember our victims who might play an active role, precipitation, and now they're sober and they need to work it out. So victims are offered some, reconciliation programs. Victim notification is something else that is provided. This is keeping the victim informed and in the loop, and providing them with active court updates. Other updates such as, remember that defendant that was sentenced to prison? You were the victim. He's being released. Especially, that's very common. Domestic violence cases or stalking cases. Cases where there might be something called an order of protection in place. I'm going to talk about those next. Sex Offender Registration Acts requires those convicted of certain sex offenses to register their address. So it's made public. So it's not only available to the victim, but it's also to inform the public as well that a registered sex offender is living within the community. Back to my orders of protection or legal protection for victims. Let's talk about those. There are services that help victims get these orders from courts to help in protecting them. This is primarily domestic violence cases. You can get these orders without there being a criminal charge involved. That's why they are kind of merely for domestic violence. I'll give you the parameters here in a second. It starts with something called ex parte. They call the first one an ex parte order, EXPARTE. This is where an individual goes to court. In New York, it's family court. The book has the example of a Massachusetts statute. That statute is very similar to the one in New York, so I'm going to use it. The occurrence of, this is what you need, the occurrence of one or more of the following acts. It has to be between family members or household members. Now you see why we're in family court over this, and it has to be domestic violence because the parties involved can't be strangers. They have to be family members or household members. So you can have a brother, sister, husband, wife, mother, child, boyfriend, girlfriend, partners, separated spouses going through a divorce. You can have that. So you have to look at the relationship between the parties. Let's just say we have husband and wife. We got our parties, and now you need one of the three. Somebody is attempting to cause physical harm. So let's say the wife went to family court to get an order of protection. She was being abused. So you need somebody attempting to cause physical harm. or placing another in fear of imminent serious physical harm, or causing another to engage involuntarily in sexual relations by force, threat, or duress. So the person who wants the order of protection, which will say this person needs to stay away from me, 100 feet, thousands of feet away from me, don't talk to me, don't contact me. It's a stay away, no contact type of order provision. And that's what the person has to show. So as you can see, by looking at those three conditions, one of those three conditions, you don't actually have somebody touching somebody, right? Attempting to cause or to cause, placing another in fear of imminent serious physical harm. And then the third one, you're having contact, causing another to engage involuntarily in sexual relations by force. And the court takes this information down, either in an affidavit form, or sometimes the court will take testimony. Raise your hand. Swear to tell the truth, the whole truth, nothing but the truth. And we'll hear testimony. That's what it's called. And if those things exist, the court will sign that order, ex parte order. And the next thing that happens is the accused is served with this stay away order. Usually it's stay away from the victim, the home of the victim, work, school, and have no contact, and stop whatever they were engaged in, whether it was stalking, harassing, putting somebody in fear, or harming in some way. And they get served with that order. And who serves them? Law enforcement. It's usually the state troopers that do so. But the court hasn't heard from the accused. So what happens is the court will set what's called a return date for everyone to appear, to come back. If after hearing from the accuser and the accused, the court finds sufficient evidence supporting the claim, the court will then issue what's called a full temporary order of protection. It's in place for a temporary period of time until the court can schedule a full-fledged hearing. Well, they'll have all the witnesses, everybody has an attorney, and evidence gets presented. And if in the end the court finds that the conduct has happened, would ultimately issue a full-fledged permanent order of protection. And they do have dates. It depends on what the claim is, depends on if there was a criminal charge involved. If there was contact, there would certainly be a criminal charge involved, but not necessarily has to be. And that's the minimum is 1 year. The minimum is 1 year, and the max can be quite extensive for the length, especially for a child. It's usually to their 21st birthday and such. So it could be a long time. And those three conditions aren't the same universal statewide. Every state has their own version. I know in the state of Pennsylvania, you have to actually have a contact. Putting someone in fear isn't enough. So, a little digression there on talking about the orders of protections, but they're very important, and they do come into play, and they're very helpful to victims. Now we're going to move on to victims' rights. Victims' Bill of Rights, they were established in 2004. The federal list of them is on page 85. Actually, I think they're all right here on my slide. Each state has enacted their own Victims' Bill of Rights. New York State has theirs. It's found in our executive law, and I put a link on Moodle so you can see them, but they're pretty straightforward. They seem to follow the federal ones. Victims of crimes have the right to information in certain cases and compensation and services. So these rights are explaining of what they're entitled to. So they're entitled to a free, I'll read you the ones from New York because the ones from the federal statute are right here on my slide, and they're in the book. So in New York, a free copy of the police report, even if there was no physical injury. Payment, waiver of fees for replacing driver's license, permit, registration, and license plates that were lost or stolen as a result of a crime. They have the right to have law enforcement and the district attorney inform employers that the criminal case may require work absence. They have the right to not be penalized by an employer when appearing as a witness in a criminal proceeding, consulting with prosecutors, or exercising other rights under the law. They have the right to file for victim compensation and assistance with the New York State Office of Victim Services that we just talked about. They have the right to be notified of criminal proceedings. They have the right to be free from intimidation, threats, and harassment. And they have the right to notice of any discharge, release, or escape of the offender from a correctional facility. So those outline the Crime Victims Bill of Rights here in New York State. They're pretty straightforward. You can check out the link on Moodle. The ones from the federal are right there. And lastly, in talking about caring for the victims, I've already spoke at length about victim advocates. I will point out here that advocates don't necessarily have to be part of a service or an agency. They can be independent, and they can be independent depending on their experience. Attorneys can be advocates, and they can consult victims through a court case, and a lot of victims actually retain or pay for an attorney just so they can have their own legal counsel and be kept in the loop and have a understanding of the case from beginning to end. And we're going to wrap up with self-protection. Not all victims rely on victim services or seek out victim services. Some actually decide to start up neighborhood watches or take other sort of measures to protect themselves, maybe install security cameras, or maybe they take a self-defense class, and some even buy weapons for protection and intend to take matters into their own hands. And some victims fight back, and some do frustrate their attackers and prevent the crime. But on the other hand, the attacker might find it insightful, and the victim could be hurt even more. So that's a fighting back and using, their own weapons. It's a catch-22. But that finishes our discussion with regards to victims and victimization. Next week is the exam, chapters 1 through 3, and we'll do chapter 4, and we're going to talk about the rational theory. And also, your paper topic needs to be submitted, and I'll address that in a separate email or video to you guys.